Hello, good evening and welcome to another program on Law and Order, the program that highlights on an area of law every week and bring you an expert opinions and information about that law. Today, we're going to discuss on an area of law called simply writs. And to do that, we welcome back an expert on that, Rajiv Amarasuriya, attorney at law, who is no stranger to our studios. Rajiv, welcome back again.
Thanks, Chanakya. It's nice to be here once again.
It's nice to have you. I thank you for taking time off your busy schedule. And I know our recording times are not very suitable, but thank you. Lot of questions on this writ area I have. But let me start by asking you, what is the writ jurisdiction presently in Sri Lanka?
The writ jurisdiction in Sri Lanka emanates from Article 140 of the Constitution.
Right.
If I'm just, it might be relevant for me to read this provision out. 140 provides that subject to the provisions of the Constitution, the Court of Appeal shall have full power and authority to inspect and examine the records of any court of first instance or tribunal or other institution and grant and issue according to law orders in the nature of writs of certiorari, prohibition, possidendo, mandamus and quo warranto against the judge of any court of first instance, tribunal or the institution.
Right.
So that is from where the writ jurisdiction in Sri Lanka emanates from. Also, we rely a lot on English authority because, as I mentioned on the previous program, these prerogative remedies actually organically developed in England. And so we rely on much of the principles, but we have locally also the jurisdiction has now developed over the last 15, 20, 30 years. With the introduction of the 13th Amendment I think it was in 1987, we have the provincial council list, the powers of the provincial councils. So in respect of those matters, the writ jurisdiction was also devolved to the provincial high court. So if someone has a complaint on a matter which comes within that list, then you can go to the provincial high court. However, the Court of Appeal still has the concurrent jurisdiction. So you are not forced to go before the provincial high court. You can always come before the Court of Appeal. And through experience, we find that still most matters come before the Court of Appeal. Possibly because we have 2 dedicated courts in the Court of Appeal, and we have practitioners who specialize in this area also practicing before the Court of Appeal. So that is how the jurisdiction.
Now, what are the types of writs, if I may ask that question? Types of writs we have?
We have several types of writs. The writ of certiorari is the most common we may make use of. That is a writ by which you go to court seeking to quash decision, order, and action of a public authority, which is outside its legal mandate or legal authority, its jurisdiction. It might have certain powers to exercise, and if the decision is outside those powers, the authority, then we go before court and seek a writ of certiorari to quash that decision.
Right.
Then we have the writ of prohibition, which is interconnected with the writ of certiorari, where you can go before a court and seek an order prohibiting a public official, a public authority from making the decision saying, well, it is outside your mandate. So that is a writ of prohibition. Then you have a writ of, the third writ, which is also commonly made use of, a writ of mandamus, where you can go before the court, where, for example, when there is a public duty to be performed by a public authority and the public authority has not performed that duty, you can go before the court and seek an order compelling that authority to perform that public duty. Then you have the writ of possidendo, which we don't make use of so much. That is to order the valid exercise of power. A writ of quo warranto, which is where you challenge the authority of a person holding public office. So you have to have the authority to hold public office.
Yes.
The writ of habeas corpus, which is to present the body of a person in detention, so that one could consider whether he or she has been detained legally. So those are the various types of writs which we have.
Now the writ of certiorari, which you said, we have seen, at least I have seen, which is a commonly sought writ, right? Tell us a little bit more about this.
This goes back to about writ of certiorari in its present form goes back to about 1920, in the 1920s, when there is this famous formulation by Lord Atkin in the Electricity Commissioner's case, where it was held that where a body of persons having legal authority determines questions affecting the rights of persons, and that authority has a duty to act judicially and acts outside, in excess of its authority, then that decision is subject to the jurisdiction of court.
Right.
So there are certain requirements you need to, well, initially it is a body of person, but it can be obviously now today even a citizen.
Even a citizen,
a public official.
Yeah.
Having legal authority. Strictly speaking, now there are instances where it's beyond legal authority also. You might have instances where you have certain rights, you have legitimate expectations, and affecting the rights of citizens. We have actually in 2005, we had this important case, Harjani versus the Indian Overseas Bank, where the court upheld these principles, and it went beyond, and it said that it when one complains of a decision, that power need not necessarily be derived from statute, and it could be a non-statutory power as well. So for example, where if you have, say, professional bodies, commercial, even commercial bodies which control and have exclusive or exercise executive power over citizens, then you might have a situation where you can invoke the jurisdiction.
Right. Now, you mentioned about, when you mentioned the types of writs, about writ of certiorari as well as a writ of prohibition. Now, a litigant might have a little bit of a confusion in this. Can you explain a little bit about the prohibition and the similarities and the differences in that?
Well, they are very, of course, the lawyer will assist the litigant who has a difficulty, but it's very similar, because the writ of certiorari is, you go directly and say, well, there is a decision which has been made.
Yes.
This is illegal.
Yeah.
This is ultra vires. You do not have the power. There are several instances. Either the person doesn't have the power. Often we find situations where a officer is delegated with the power, but somebody else has made the decision. That is illegal.
Yes.
Then you have the prohibition, where you go before the decision is made, and you get an order saying, well, don't do this. You can't. You don't have the power to do this. And the court says yes, accepts this position, issues a writ of prohibition.
Right.
So it's a prohibiting order.
Yes.
As opposed
before
to
the act.
It's a before the act. Yes.
Okay. Now, the situations where you can take this to are almost on any decision a public official or a public body makes. That's what you're saying, no?
Yes, but there are grounds of review. There are various. We call it grounds of review. Where now it applies to most decisions of public authorities, but there are certain bases on which you can go before court. I mentioned earlier also, you have the doctrine of ultra vires.
Yes.
That is the most common basis we make, where decisions are set aside. That is where the authority acts outside the jurisdiction. Very simply, if you go outside, then your decision is ultra vires, illegal, and it can be quashed by court. Now, actually, there was, I think, in Professor Wade's book, there's an example where he says, even when, for example, take the example where a local authority passes a bylaw, which is very unreasonable, which is pernicious, the courts could take the position that, well, strictly speaking, they might have the power to pass the bylaw, but the courts could take, these are hypothetical, courts could take the position, well, when Parliament gave you the power to make bylaws, they did not intend for you to make these very arbitrary and unfair bylaws. You don't have the power to make these bylaws, and say it's ultra vires. So this is where the law is heading. So the doctrine of ultra vires is developing as we speak. And now it's very wide jurisdiction. Then we have the second ground of review, which is commonly used. No particular order, but for purpose of convenience. Contravention of the principles of natural justice, which you have heard of. That is the right three categories: right to a fair hearing, audi alteram partem, the rule against bias, and the right to reasons.
Yes.
Now, if I'm to describe a little bit more on the right to a hearing, that is a basic right, first principles. This is an aspect of participatory democracy. Now, if take a simple example, say there is some disciplinary inquiry, say in a in the public sector. So the right to hearing would encompass the notice of the charge being provided, charge sheet, disclosure of all relevant material against you, the opportunity to make an oral hearing, the opportunity to be represented either by a lawyer or some public official, the right to summon witnesses, then and also adequate time to appeal.
Yes.
So those are all ingredients, or all requirements which natural justice will require or will mandate that you are provided, and the failure to provide these various safeguards would result in another ground of review on the basis of the failure to provide that person
the opportunity,
the protection of the rights under natural justice.
Right.
Then we have the rule against bias.
Yes.
That is the rule that no man should be the judge of his or her own cause.
Yes.
So there are various. There is no degree of bias like some of the other grounds.
Yeah.
This is where if there is bias, the decision is vitiated.
Yes.
So the decision maker might have a pecuniary interest, some commercial monetary interest in the decision being made. Then that would be a biased decision. Might have some professional or family interest in that decision being made. Then there are cases where he or she might have some personal knowledge, prior knowledge, which is irrelevant to the consideration. And that would be also a case where bias kicks in.
Yeah.
And also where, for example, now we have situations where you have a decision-making body and an appellate body. I'm not referring to the court system, but in the administrative process, the government structure, and say the member in the original decision-making body is also a member of the appeal body.
Yeah.
Then that is a case where there is bias. So that is another ground upon which a decision in the public realm, of a public authority could be set aside, or sought to be set aside. Then, of course, the third limb of natural justice is right to reasons. The courts have said not only only does one need to provide reasons when you are making a determination, but you need to know. Say you have adverse order which is made against you. You need to know what the basis is, even to appeal. And the courts have gone. There are several judgments of Supreme Court saying, well, not only reasons, the reasons must be sufficient. So those are the limbs of natural justice.
Right.
Then we have several other grounds. Where we had earlier ground of error on the face of the record, which is within jurisdiction, but that's actually now something which has been bypassed by the concept of ultra vires. We don't need to discuss that aspect. Yeah. Then we have the other ground of review, which is reasonableness, unreasonableness. You can go to court and say, well, the decision made is patently unreasonable. The test of a reasonable person. A reasonable person would never have made this decision. So that is, and we have this dictum, the Wensbury, the judgment in the Wensbury case in England. That was a case, they cited an instance where a teacher, a school teacher who had red hair, had been terminated.
Yes.
And the court held that was unreasonable. Firstly, it was not reasonable to do so, and in any event, the red hair was irrelevant consideration in terminating the teacher.
Yes.
So that is another ground upon which you can challenge a decision of a public authority, reasonableness. Then we have the legitimate expectation. That is just something which we sometimes talk about. It's similar to promissory estoppel, akin to promissory estoppel in private law. This is where a public official makes a representation, makes a promise, says, well, we will do this, and then departs from that representation and does something else. You have held out to the public, and the citizen or the group can go before court and say, we have a legitimate expectation that this will be done in this way. However, it has not been. Initially, the law, the principle was that if there is a legitimate expectation, to change that decision, you need to provide a hearing, you must give reasons, provide an opportunity to that person you have provided the representation to, and explain that we are going to make the decision. That is procedural legitimate expectation. But that has now developed into also substantive legitimate expectation, where actually you derive rights. Now I was led by my senior at the time, Mr. Sanjeev Jayawardena, and we appeared for some citizens of some residents of housing scheme close to Colombo. And those residents for about 15-20 years had correspondence from the relevant public authority saying that the land which is in between their houses will be used for an open space and a playground. And that was the consistent, the letters they had. Then suddenly one fine day, they decided to convert this playground into and use that land for a building. So the citizens, these residents went to court and complained saying we have legitimate expectation. And the court upheld this position, the Court of Appeal, and held that, well, you have given this holding out. There is a representation and this should be used for the purpose of the playground. And that is a case where it was actually substantive legitimate. There was a right which these residents had due to the representations made.
Right. Now, thank you for those very elaborate explanations. To cut short in time, I'll ask you to answer in short, if I may. The writ of mandamus is another popular writ. When is this taken?
The writ of mandamus is a writ to compel a public authority to perform one's public duty. I will take a simple example to explain a writ of mandamus. Now we have this big garbage issue at the moment. Yeah. I am not referring to it at present. Yeah. Say we take ourselves out of the present and say in the future or 2 years ago, say that your local authority does not collect your garbage. Now in terms of the municipal council's ordinance, urban council's ordinance, the collection of refuse is the responsibility of the local authority. That's a public duty. So you can go before the court. Before that, you first make a demand. You make a demand on the authority. You write a letter and say, well, you are under this provision, you have to collect our garbage. However, for the last 2 weeks, you have not 2 weeks or 2 months, you have not collected our garbage. You are not performing your public duty. And then, if they don't perform, then you can go before the court, seeking the court to intervene and compel them to perform a public duty. From very simple example, but that is how the writ of mandamus works.
Now, we mentioned about the type of writs and how you file. What is the procedure of filing them, and can also in existing case people intervene in writ applications?
In response to your first question, I briefly, in view of the time constraint, to file a writ, you have to, the writ is, you first file a petition together with a supporting affidavit. All this is by way of documentation. There is no separate leading of evidence like in the original courts. Then you support the application for the issuance of notice. That is where the court accepts the case. You can also seek to get a stay order at that point. The other side might be represented. Then if the court issues notice, then they will give opportunity to the respondents to file their objections. Then the petitioner would get opportunity to reply through a counter affidavit, and then the matter will be fixed for hearing. So once the process is concluded, the matter will be taken up the substantive issue, and the court will issue the issuance order. In respect of intervention, unlike in the case of fundamental rights, unlike in the case of the Supreme Court, where the Constitution specifically provides that interested parties could seek to join applications before the court, in the Court of Appeal, neither the Constitution nor the Supreme Court and Court of Appeal rules, which mandate the procedure, specifically provide for intervention. So we don't have a positive rule saying you can intervene.
Yes.
In the past, there have been instances where the Court of Appeal has actually allowed intervention of applications. The present status quo being that there have been several decisions in the recent past where the court has taken the position that there is no specific provision. And that on that basis, there is no provision to intervene in the Court of Appeal.
Right. Now, when action is filed, what are the defenses that the respondent can take?
There are several defenses that a respondent could take. Let me just, lashes is one. That is delay, where you come before court and say you have to come, you cannot sleep over one's rights. You have to come before court during within a reasonable period of time. But there are also instances where the court say when the decision is a nullity, there's a patent void of jurisdiction, there is no authority at all, then of course the time bar may not apply. Usually, generally, I mean, you can't prescribe a time limit, it depends on the case, but 2-3 months, there is, unlike in fundamental rights, it's 1 month, 2-3 months, it's fairly reasonable. But it depends on the case. If the case is rendered, if everything has happened, then you can't 3 months later go and try to have it. It depends on the case, but lashes is one basis where you can be denied relief. Then you must also name your necessary parties. You have to name the right parties when going to court. Those who have been aggrieved by the decision, those who have been benefited, those who are party to it. You have to bring all of them. You can't just make one respondent and leave everyone else. Then the case can be dismissed on that ground alone. Then we have situations such as uberima fides. You must go. You have to go to court with clean hands. You have to go with. You have to have complete disclosure. If you can't suppress, and suppression would also result. A suppression of information could result in the dismissal of an application. Then there are then for example acquiescence. Say you have acquiesced. Say you have been party to the wrongdoing, or you have accepted that also would be a ground upon which your case can be dismissed. There are several grounds like that.
Right. Now, these we were talking writs against the act of public official or public corporation. Can they be applied against a decision of a corporate body or on commercial matters?
Of course. The writ is available to any person. So a corporate body also would come within that definition. And it all before I actually respond to that particular question, I would say that from a corporate perspective, one must be conscious of the writ remedies for two reasons. One is, of course, you can make use of it. Now there are cases, you have licensing cases, you have customs orders coming against you, you have various rights, applications, approvals from the state, which you have sought, which you have maybe denied, may have been given. So you can make use of this remedy from a corporate, and then lot of the cases we do actually have from the corporates. But also the converse. You must be aware that when you get a benefit or a right from the state, you might get some concession, you might get some exclusivity, you might get a tender. You must be conscious that if you don't get it in the right way, somebody else can go before the court and challenge it. So, I mean, you must ensure that due process. I mean, sometimes what happens is, especially in this area of law, procedure is vital. If you don't follow, maybe the ultimate end result may be acceptable, but if you have, since it's a public body, they must follow the procedure. They have the financial regulations, they have the establishment code, they have various other procedures. So if that is not followed, then it can be set aside. So from a corporate point of view, as much as you can make use of these benefits, of this remedy, you can be the subject matter. You can be denied of a right, something you have obtained by someone else going in. And we discussed public interest litigation. You might have a public spirited citizen saying, well, how did you give this? You didn't follow the procedure. So that from that point of view, and the corporates make use of it a lot.
Rajiv Amarasuri, thank you very much for those insightful thoughts on writ jurisdiction and the law, and thank you for joining Law and Order today. Thank you very much.
Thank you, Chanaki. Thank you.
Okay, that's Law and Order for today, and we'll join you next week with another program on Law and Order. In the meantime, you can go to our Facebook site, Facebook/Law and Order Channel Live, Facebook/Law and Order Channel Live, and post your comments or your suggestions. Enjoy the rest of the night and the rest of the programming on Channel I. Have a good weekend and good night.